Hello, everybody. Welcome to the installment of In the Boardroom for December 13. We are allowing participants to gather, and in a couple of minutes, we'll get going with the discussion. So once again, we'll be starting the discussion a couple of minutes after participants have joined. Hey, it looks like we've got a critical mass gathered. Good afternoon again, everybody. I'm Andy Phillips, and with me on the line is my partner, Jake Curtis. We're here to talk about county board rules, and this is part one of the two-part series involving county board rules. As you might remember, we took a brief break in November to allow counties opportunity to deliberate on the budget and otherwise enjoy the Thanksgiving holiday. And then this month, we're going to do two different discussions. Part one is county board rules. Part two is a deeper dive on some of the county board rules. Couple of housekeeping matters as we start off here. This is intended to be a discussion. We're in the boardroom where discussions occur. We're not in a purely presentation mode. And so you get the most out of it. We get the most out of it if you ask questions. So if you have questions or comments, please use the Q&A button or the chat button on your screen. We will monitor those throughout the presentation so that we can get the information that you need. This topic is an interesting topic, and it's one that counties are grappling with right now because we've got an election coming up in 4.5 months. At that election, new boards will be elected, and we will have an organizational meeting that occurs in the third week of April. At that point, the new board is going to have to determine how do we govern ourselves and what are the rules of our organization. And so I think a lot of counties are going through the process right now of figuring out, if we don't have board rules, do we need board rules? If we do have board rules, what rules need to be updated, clarified, changed, and so on, so that we are set to hit the ground running in the new year. So perfect timing for this discussion here today. I know I've had separate conversations with several counties about updating and dusting off those board rules and trying to make sure that from a governance standpoint that we have all the right pieces in all the right places. So for purposes of today, which is again, part one of this two-part series, for purposes of today, we want to understand the importance of county board rules. What do they do and what can they help accomplish? Understand the freedom that's provided in section 59.03 of the Wisconsin statutes, because not all counties are going to be run the same way, and that's okay. And so understand that 5903 gives us a lot of freedom to define how it is that we are going to organize ourselves from a governance perspective in our particular county. Along those same lines, board rules are not one size fits all. I often get asked, hey, do you have some template board rules, or do you have a sample set of board rules that you can send out? Happy to provide examples, happy to provide perspective, but understand that this isn't simply cut and paste, that you need to put some thought into how it is that you want to operate within your particular county. And so today, hopefully, is going to be a discussion starter for you, not a discussion stopper. You want to identify the key points where you think that you can make a difference in the board rules within your particular county, how you can help organize and run the county in a better way from a governance standpoint. So identify those key points today. And then finally, this discussion is a guide and a launch point for the discussion that we're going to have 1 week from today. And we're going to have this discussion, I anticipate, for many, many years to come. Good governance is an evolution. It's not a stopping point. So understand that if we are committed to good governance and we are committed to running things in an effective and an efficient manner, that we are constantly going to be looking for opportunities to improve upon what already exists. Real quick too, before I forget, this discussion is being recorded today. It will be available on WCA's website. When we're done here, as long as it takes for Zoom to compile the recording and send it out, that's when we'll get it on the website. The PowerPoint slide deck is also going to be available on WCA's website. So, Jake, I introduced you at the beginning, and I've been babbling for about 4 minutes. What else do you have to add to this before we dive in?
What's the expression? I'll keep my powder dry.
I think that's
I
a
mean,
good
I
one.
think this is a good introductory slide, so I'll chime in on a few of these because I think that you're raising some really important points.
Well, and I think, Jake, too, the important perspective I want the audience to know is that I will tell you, I'll be the first to tell you that I have never sat in the seat of a county board supervisor. I've never done that job. It's a terribly difficult job. I certainly appreciate that, but I don't have that perspective of saying, when I was a supervisor, here's what I wish would have happened or wish I would have known, so on. Jake, you've sat in that seat. And so I think you understand just how daunting a task it can be for that new supervisor to sit in that seat for the very first time and be asked to govern.
Yeah, that's true. But I would say from that perspective, when I was appointed to my seat, one of the first things I was encouraged to do was review the board rules because, I mean, to our first bullet here, understanding the importance of county board rules. Obviously there's state statutes, there's ordinances, but at the end of the day, it's really those board rules that are going to dictate how the rest of the county business gets done from a board perspective. So again, I think these are good introductory points, and I definitely am going to chime in here.
All right, so let's lay the foundation here. When we talk about rules of procedure that are applicable to county board or county board committee proceedings, there is an order of precedence here. Of course, state statute is going to supersede local rule, is going to supersede Robert's rules, and is going to supersede customer practice. So the first thing you have to look at is whether a state statute requires you as a county board or county board committee to act in a certain way. Great example of that is the open meetings law. We cannot have a local rule that conflicts with the open meetings law. The open meetings law takes precedence over local rules. The same with a matter that's addressed within Chapter 59. If it's addressed in Chapter 59 that you shall do business in a certain way, you have to follow that statute. But then next in line after state statute are your local rules. We'll talk about the question in a moment. We'll talk about the question about whether you should codify your local rules in ordinance, separate debate. But local rules take precedence over Robert's Rules of Order. If you don't have local rules that address a particular situation, you turn to Robert's Rules of Order. And if none of those sources, state statute, local rules, or Robert's rules, address a particular question, we can resort to custom or practice to define how it is that we are going to act in a particular circumstance. So understanding this order of precedence is really important. It's really important because I often get asked the question, I know Jake gets asked the question, well, Robert's rule says that there's a 2/3 vote that's required for this particular question. Our local rules say it's only a majority vote. Our local rules don't comply with Robert's Rules of Order. Therefore, our local rules aren't enforceable. That's not true. Your local rules can modify Robert's Rules of Order. So understanding from a foundation perspective, the order of precedence as it relates to the procedural rules for your particular county board or county board committee is very important. I mentioned early on that you have tremendous freedom under 5903 of the statutes, and I wanted to put this statute up here so everybody could just see the actual language here. 5903 sub 1 came into the statutes in the mid 1980s. Huge lobbying effort by the Counties Association to say, look, county government is not given the same freedoms that municipal government is given, yet you're asking us to do incredibly complex things. We ought to be able to organize the way that we see fit. Legislature, in their wisdom, two words that I often don't use in the same sentence, but the legislature, in its wisdom, said, counties, you're right. We're going to give you administrative home rule authority. So right there in 5903 sub 1, every county may exercise any organizational or administrative power subject only to matters of statewide concern that are contained within the Constitution or the statutes. So understand the freedom that is provided by 5903 means that every county does not have to have the same rules associated with board procedure or committee procedure. If we look at Robert's Rules of Order, and I looked at the newly revised 12th edition, the 12th edition is the latest edition of Robert's Rules. Even Robert's Rules recognizes the existence of rules that would govern the proceedings before a particular body that are different than Robert's rules. And so if we look at chapter 2, sections 14, 23, and 25, here we have recognition within Robert's rules that says you can adopt local rules to govern your proceedings that are either inconsistent with or fill the gaps that are created in Robert's rules. I really like 223 standing rules. If we think of standing rules or rules that are related to the details of the administration of a society, and in this context, the society is talking about the county board or county board committee, rather than the parliamentary procedure, in which can be adopted or changed on the same conditions as any ordinary act of the society, those are standing rules that can exist, and you can define how those standing rules can be adopted. Finally, I want to note here, because oftentimes I hear the phrase out of the mouths of county officials, when I say, why do you do it this way? They say, that's the way it's always been done. All right. And I never like that answer, because just because it's always done that way doesn't mean it always has to be done that way. Be that as it may, custom and practice can play an important role as it relates to rules or procedures. Because if it's not addressed in state statute, not addressed within your board rules, not addressed in Robert's rules, a particular custom or practice may carry the weight associated with the way a particular matter needs to proceed in order to be considered as an item of business before your county board or county board committee. So again, customer practice can play a role in that. I will tell you that I would like to see customs and practices codified within your board rules, simply because it's hard to tell people what customs and practices are unless they're in the board rules, and you can have that discussion with folks. So I prefer very much to see customs and practices put into your board rules, but just understand that there is a role, or there is a spot for customs and practices in this discussion.
Well, Andy, and on that point, maybe just a little wrinkle is, and we see this where you can have a custom and practice that's not in your board rules. What we also see, though, is a custom of practice that has maybe evolved over time and may ultimately even be inconsistent with a board rule, which I think gets to the ultimate point here as to why we're doing this, that you need to constantly be reviewing the board rules to ensure that, if you have some customer practice that has developed over time, that's not a bad thing, but then it may result in a need to then update your board rules, to your point, to incorporate that custom and practice that maybe has become a significant one that the board wants to follow. But if there's no board rule in place, or again, we see this, if it's actually inconsistent with a board rule that maybe hasn't been updated in years, decades, that's why you need to ensure that you're constantly reviewing that. And if you have a custom of practice that's evolved over time, that's fine. But then make sure, if you want it to continue, you then incorporate that into a new rule or revise a rule that's in existence.
The other question we get asked a lot is, when is the appropriate time to look at our county board rules? And there's never an inappropriate time to look at your board rules, but if we think about it in terms of the cycle of county governments, we have two very important cycles that occur. We have the annual cycle as it relates to budget. We have budget development, budget introduction, budget deliberation, budget adoption. That ends in November of every year. Okay, so there's a definite cycle as it relates to budgetary policy within a county. We also have the election cycle. So every 2 years, we have new board members or returning board members seated the third Tuesday in April, and they get together and have their organizational meeting. And one might think, hey, it makes sense to adopt the board rules at the organizational meeting. I'm going to tell you that I don't think personally it makes a lot of sense, simply because the new board isn't going to have the insight and experience that the existing board would have had in order to figure out exactly what rules need to be amended, modified, updated, changed, whatever. And so I think it makes sense for right now counties to sit down and start taking a look at their board rules with an eye toward adoption in March at the latest, before the election, so that at the organizational meeting, you can have a discussion with the new board. Everybody who's seated, here's what our board rules are, here's what they mean. And then if new board wants to take up board rules and wants to change one, you can do that. That's fine throughout the entire next 2 years, but then every 2 years have a cycle on updating and dusting off those board rules. I think if we have that type of cycle ingrained, kind of like how our budget cycle is ingrained within our being as county officials, I think we'll be better off. And so we just create a calendar that every couple of years we take a look at the board rules, and we know that come December of odd numbered years, January of even numbered years, we ought to be really thinking about updating our board rules if they need updating, and doing what we need to do to put those new board rules in place prior to the April election. Now, I have a question on the last bullet point here. Should the rules be incorporated in a county ordinance? And for a long time, I was either ambivalent on that or I said no. And the reason for that is that if they are not in ordinance, they are easier to amend. You don't have publication requirements. You don't have other requirements associated with adopting an ordinance. An ordinance is just a lot more formal legislative act than a simple resolution. All right. So that was my prior inclination. And by the way, there's no rule on this. So anything that I am saying here is just based upon my experience and my thought put into the whole board rule process. But now I tend to think that having an ordinance that codifies your board rules is a good idea. Because if we want to establish what will be viewed as the permanent rules of procedure, the way that we're going to govern ourselves, we want them to have some level of permanence. We don't want them to be amended each and every meeting. Amending an ordinance is a lot different than simply amending a resolution or having a new resolution which amends a previous resolution and so on. And so, at least in my mind, it makes sense to codify in ordinance these board rules. The other thing it does, and this is just purely pomp and circumstance, is that there's a level of formality to county ordinance. When you publish your county code to your website, or you use MuniCode or some other service to publish your code, your board rules show up there. It puts the public on notice. This is the law in our county. If the board rules are in those ordinances, you're saying these are the rules. This is the law that we are going to utilize to govern ourselves. I don't think that's a bad idea. Now, again, there's no requirement that you codify. I'm just suggesting that on a personal level, I think it makes a lot of sense to codify within ordinance. Jake, do you have thoughts one way or the other on that one?
No, I would agree. I think having a level of permanence is a good thing. But that in my mind, I was actually gonna, I guess, ask a question for purposes of kind of generating a conversation, and that is,
It's not going to be controversial, is it?
Well, it depends on what county you're in.
Okay.
Because we've seen this with some of our county clients, and that is okay. So bullet 2, you rules are adopted prior to organizational meeting and then reviewed at the organizational meeting in April. Okay. You have a discussion, everybody reviews them, and then you approve them. Okay. July or August, there's a significant number of revisions that a group of supervisors want to make. In other words, kind of changing those board rules halfway through maybe a term. I guess what is your view on that? Because again, we've seen different scenarios where I think it's one thing to maybe add a board rule, to my previous point, you have a custom and practice, it's not codified, there's a conversation and debate, and you include a board rule. What I'm getting at is we've seen situations where despite kind of a board's approval of these rules, there is an effort to kind of do a wholesale revision halfway through a term. And I'm not suggesting there's a right or wrong answer here, but that I think can cause some issues. Because again, I think a one-off revision or addition is different from kind of a wholesale revisiting of board rules that have already been adopted. So that I think there's a question in there.
Well, and I think that's a good question, Jake. It gets back to the whole issue of how permanent do we want our board rules to be? Again, talking about my personal preference, I would like to see a requirement, a supermajority requirement in there to either amend or suspend any board rule, 2/3. And you can set it at 3/4 if you want, but I think 2/3 is sufficient. If 2/3 of the members of a board think that we ought to change a rule, then the rule probably should be changed. That's the overwhelming majority of supervisors. If it's just a simple majority, I think you got to wait. You got to wait until the next time you take a look at the rules. And so I think that the body itself, the county board, obviously it's the county board's rules. And so the county board, if the county board wants to amend them, the county board certainly can, just like any other decision it makes. That said, if we want to create a level of permanence as it relates to the county board rules, and I think we do, then let's make it a supermajority requirement to amend or suspend. What do you think?
I think that's right. And then I think that segues into the third bullet that if there is an increased, permanence that they're in an ordinance, then I think that would even make it more difficult uh to amend kind of halfway through. And again, not to say that there may be situations where that's necessary, but again, we've seen issues where, I mean, the rules seem to be changing multiple times throughout a term, which I think can raise some issues. And if the point of the rules, like I said, when I first got into my spot, the first thing I did was look at the board rules. If they're constantly changing throughout a 2-year term, they're not really serving their purpose. They're not providing direction. So I think to your point, yeah, if 2/3, if they feel that there's a need, then that can probably lead to those positive changes, as opposed to a simple majority constantly changing the rules throughout a term, which, I mean, there's no certainty at that point.
Agreed. All right, so organization of county board rules, again, there is no template for this, so you can organize how you want. But what I would suggest, and I think what Jake would suggest, is that you have some sort of organization. If you look at the Wisconsin statutes, for example, each chapter has a particular title, and you know that every statute falling under that chapter is going to relate to whatever the title of that chapter is. Let's organize our board rules in the same way. An example that we use is first chapter deals with county board officers, second, organization of the county board, and third, procedural rules that govern the proceedings before the county board and its committees. So, I mean, honestly, you can follow this. This is awesome. This is the way we like to see it organized, but you can organize it any way that you see fit. The point being is to organize them so that people can find information, so that the presiding officer and parliamentarian can find information in an easy manner, that it's not digging through 30 pages of single space type to find the answer to a point of order that's raised at a meeting, that you've got this organized in a way that makes sense. So takeaway from this slide is just organize them in a way that makes sense so that it's digestible for everybody who is going to use those rules. So let's talk first about county board officers. We're going to start with statute. Remember, we talked about the order of precedence here as it relates to procedural rules, where we have a statute that talks about county board officers. We know that the board, at the first meeting after each regular election, that's the organizational meeting, they elect a chairperson. All right. We know that has to happen. So we cannot have board rules that say we elect our chairperson in July. Nope. We know that at that third Tuesday in April, we're going to elect a chair. All right. And then we also have in 59.12, the duties of the chairperson. We can always add to the duties of the chair, so long as it's not inconsistent with or otherwise negates the duties that are contained in 59.12 sub 1. All right. So again, 59.12 sub 1, we have to elect our chair. At the same time that we elect our chair, we also elect a vice chair. All right. So we have a chair election, we have a vice chair election. Those are required by statute. We can also elect a second vice chair. We don't have to, we can. The legislature used the word may in this particular statute. So we have the ability to, we have to elect 2, we have the ability to elect 3. The question is, do we want other officers? I know some counties have taken a look at the sergeant at arms position. They happen to like somebody being designated as the keeper of the order at meetings. That's fine. If that's what you want to do as a county, then you provide in your board rules a sergeant at arms position, how that person is elected, and what the duties of the sergeant at arms are going to be. Remember, 59.03 sub 1, the Freedom Statute gives you the ability to do something like this within your board rules to allow you to organize to create a sergeant at arms. Another question is that we know that in statute that we have a provision that says if somebody, for example, with the chair, if we look at the statute on chair, if the chair is absent, the vice chair performs the duties of the chair. The statute uses the term absence or disability. Have we defined what an absence or disability is? Do the statutes define what an absence or disability is? Is there a process for either the chair declaring I'm absent or I'm unable to perform my duties as chair, such that that obligation now goes automatically to the vice chair by statute? That's something that we ought to think about including within our board rules. The other question that I have that comes up is, well, what does it mean for the vice chair to assume the duties of the chair? Because I think a lot of people simply think that if the chair is unable to make a county board meeting, that the vice chair chairs that meeting. True, that is true. But does that mean during the meeting, if there is something else that falls under the chair's duties under 5912 sub 1, that the vice chair automatically exercises those responsibilities and that authority? That's not exactly clear to me within the statutes. I think a good argument can be made that yes, that's exactly what happens. But that being said, are we better off defining in the board rules exactly what happens? Because again, the whole point of board rules is to avoid confusion, to avoid dispute, to avoid disagreement, and to have an orderly, efficient, and effective governance process. Well, in order to do that, we ought to define some of these rather questionable or ambiguous terms. County board chair, the other duties. If we look at this, this is where we ought to specify within our board rules certain things. And the reason that we want to specify point 1 is because Robert's Rules of Order is inconsistent with what I think everybody would agree is good governance. What do I mean by that? Robert's Rule says that the chair doesn't vote unless there's a tie, and the chair doesn't participate in debate unless the chair passes the gavel to somebody else. Well, that's all fine and good under Robert's rules, but those rules were not written with government in mind. I never ever want a chair abstaining from voting simply because the chair is the chair of that particular county board. That chair was elected to be a county board supervisor by the voters within his or her district. And so in order to represent those voters, the county board chair needs to vote on issues and should vote on issues. All right. So let's clarify that within our board rules. If it's a particularly ugly debate that is going to happen, it's a contentious matter that comes before the county board, I have no issue with the county board chair passing the gavel and relinquishing. However, if it's a matter that is either routine or it's not overly controversial, but the chair has to provide information to the board that the chair believes is going to help inform the board's vote, then why can't the chair interject in that debate? There is no bright line rule standard here. There's no saying, well, in all of these circumstances, the chair has to recuse and pass the gavel. In all of these circumstances, the chair doesn't. There's nothing out there like that. But in your board rules, you can help define the particular circumstances where you know it would be appropriate for the chair to pass the gavel. The second point is appointing members to committees. Remember, 59.13 says that the county board chair, with the board's permission, can appoint members to committees. We know that different counties do it different ways, and that is just fine. But let's define how that appointment process works in your county. Is it a chair appointment? Is it a committee appointment? Is it chair recommendation to the full board? What is that process? And then who chairs those committees? How is that process determined? That ought to be addressed in your board rules as well. Oftentimes, I think it's a good situation is that sometimes the county board chair is prohibited from serving as a chair of other committees unless that chair position is needed. In other words, it is a succession. So in the absence of a committee chair, the county board chair fills in. Define that within your board rules if that's what you want to do. Does the chair serve as a voting member or ex officio member of all standing committees, commissions, or boards? A lot of people think that the term ex officio means that the county board chair or whoever is the ex officio appointed officer has the ability to attend committee meetings but doesn't get a vote. That's what they think the term ex officio means. That's not what it means. Ex officio means by virtue of office. So if you have the county board chair serving ex officio on all committees, that county board chair has every ability to participate, debate, and vote as any other committee member. And so if you don't want that, let's define that within your board rules. Can the county board chair fill in for absent committee members as necessary at committee meetings? Again, I think that's a good thing to address in your board rules. If you have a problem trying to get quorum for a particular meeting, do we have a mechanism to get us to quorum? Can the county board chair fill in? Or if the county board chair, we don't want the county board chair filling in on all the committees, is there another process where we can get somebody else on the board to fill in for that particular meeting to make sure we have quorum? Let's address that in the board rules. Let me pause there, Jake, and see if you have any added input on that one.
On this one, I would just, I think, again, I keep, I guess, pointing out, trends that we see. I think it's important, you mentioned going through these bullets, how, have that discussion. I think when what I have seen is you have maybe board chairs that are going back to kind of that custom and practice, maybe relying on custom and practice for some of these. And I don't want to say, it always can result in contentious, debates, but sometimes I observe frustration with other board members where maybe a chair kind of relying on that custom and practice, will take the position that, they get to serve as chair of other committees when needed, kind of within his or her discretion. And then you may see some frustration with members where they say, well, what is that based on? If it's custom and practice, that's fine, but that's a pretty significant thing. And so, Andy, to your point, I think it's important, go through these sorts of issues and then decide, as opposed to kind of just leaving it to the discretion of the chair and maybe custom and practice. Have that debate. And this should be viewed in a negative way. As a chairman, I mean, you want buy-in from the rest of the board, right? So again, just using my example here, serving as the chair of other committees when needed, get the board to agree and have that as a standing rule that when needed, the chair is going to have the ability to serve as a chair of another committee, and have it as a standing rule. So there's no debate or there's no uncertainty. Again, as opposed to having it, based on custom or practice, it can result in maybe, frustration from other board members. So, on some of these, I think it's important they actually have the debate, get buy-in from the members so that there's a clear direction as to kind of what those other duties are for the chair.
No, I think that's right, Jake, because I mean, the big issue with custom and practice is that people are going to have differing recollections and interpretations of a particular custom and practice. And so you're going to spend an hour debating about what the custom and practice is. So yeah, codifying board rules. Casey had a good question. Casey, I'm sorry, I don't know what county you're from, but you say you have a third vice chair as well. Is that not allowed? No, it's allowed. 5903 gives you the ability to create that position of third vice chair. Just make sure that in your board rules, you identify what the role of that third vice chair is. Oh, Casey's in Douglas County. Absolutely. You should absolutely define within your board rules what that role of the third vice chair is, but no prohibition on doing that. All right, county board vice chair, other duties. Remember, vice chair fills in for chair in the event of chair's absence or disability, which, by the way, is not defined in statute. And so it's probably a good idea to identify a process for determining when the vice chair can fill in for the chair. Does the vice chair receive the chair's compensation while performing chair duties? I think that I am music to the ears of every vice chair out there by raising that question, but I think it's a good question. And I'd rather not have that dispute on the county board floor. I'd rather we address that in the board rules. Either the vice chair does or does not. Let's make that clear. And then clarity surrounding succession, because I hear this come up as well, is that if for whatever reason chair gets recalled, chair unfortunately passes away during the term, something happens to the chair where the chair is no longer there, does the vice chair automatically ascend to the position of chair? My answer is no. There is nothing under statute that says it's an automatic ascension unless your board rules provide for that automatic succession. The problem I've got with that is that the body did not vote the vice chair as chair. The body voted the vice chair as vice chair. The body might have made a different decision when it came to that vote if it knew that the vice chair would eventually ascend to the position of board chair. So I would not recommend that you do that. But again, let's make that clear within the board rules. Removal of officers. Chair and vice chair can be removed at any time at the will of a simple majority of the board. The Attorney General made that clear about 15 years ago in an opinion issued to Walworth County when they asked the question about, is cause required? Do we have to have notice? What do we do here? And the Attorney General very clearly said, if you look at 59.12 of the statutes, at any point in time, the board can elect a new board chair. So that begs the question, how does that get on the agenda? Because in many counties, the county board chair controls the agenda for meetings. And so how do you think it's going to go if you as a member go to the board chair and say, hey, can you put election of board chair on the agenda for the next meeting? I can just imagine how that discussion is going to proceed. And so if the board chair is unwilling to place that item on the agenda for the next meeting, which I imagine many board chairs would be, how do we get that on the agenda? Well, it kind of gets to a broader point, which is how are agendas created for board meetings? Is it the board chair? The statutes say the board chair is responsible for the agenda in terms of open meetings law compliance, but it really doesn't speak to exactly how it is that the agenda itself is formulated. And so answer the question about how an item of business like this is going to get onto an agenda. Answer the question of who is responsible for preparing the agenda. Answer the question about when that agenda has to be distributed with supporting paperwork prior to a board meeting or a committee meeting. Answer all of those questions within your board rules. In terms of other officers that aren't identified in statute, so we're talking about in Douglas County's situation, the third vice, we're talking about a sergeant at arms. In other words, a position that is created solely by virtue of the board rules. Then we can provide in the board rules how those positions are removed, how those officers are removed from those positions. And so again, I would suggest that in the absence of any board rule, those officers serve at the pleasure of the board. But if you want a different provision, you can certainly put a different provision within your board rules.
And yeah, if we could just jump back to that previous slide. I think that first or the kind of the middle bullet there is really key. I think you would agree. We see that sort of issue all the time. And so, in my mind, it's critical that there be some function for a majority of board members to see something placed on an agenda. And I think we always say there's not really a right or wrong answer on this one. I think we just see so many issues where if that is unanswered and it's completely left at the discretion of the chair, that can really cause a lot of friction on a board where a majority. I think the way you can distinguish it is for a run-of-the-mill agenda, right? You want the chair to have the discretion to working with their administrator coordinator to set up that agenda, get the agenda packaged, put it out. In most situations, right, you're not going to need other supervisors to get involved. That's clearly a chair function. However, if there's something really contentious that's kind of bubbling under the surface in a county, and you have a majority of the board that wants to see something on the agenda to either for discussion or action, and for whatever reason a chair isn't interested in having that discussion, that we've seen it where that can cause a lot of friction. And so, we've seen pretty standard language where a majority of supervisors, or maybe 2/3, again, whatever you decide, but there's some function so that if a group of supervisors want to see something on an agenda, there's a mechanism for them to do that. And again, we don't want there should be a process and should be clearly outlined in the board rules, but have some mechanism so that supervisors can work through a process to get something on an agenda. Otherwise, it can cause a lot of frustration.
Well, and Catherine from Eau Claire County raised a good point. She said there is a statute, 59.11, that allows supervisors, a majority of supervisors, to petition for a special meeting. That's good. That is a statutory mechanism to have an agenda set and call a special meeting of the Board of Supervisors. The reason I don't like that particular process is that it is fraught with open meetings law issues, because what is inevitably going to happen is that there is going to be discussion about that special item of business, no matter how many times me, Jake, corporation counsel, county administrator, no matter how many times we say, don't discuss this, people are going to have those discussions. And so an easier process is to have board rules speaking to this concept of who sets the agenda, how do items get on the agenda, and how are we going to deal with this procedurally? But Catherine, you're absolutely right. There is a process in 59.11 to call a special meeting of the board. All right, so
Unfortunately,
organization
Andy,
of the board.
you and I have worked through that before, where there's you know, really a significant potential for litigation. So Catherine's right that it's an important option to have, but it's going to be far easier to have it just in board rules, because we've unfortunately seen how that can go really badly.
And I suppose as lawyers, we shouldn't complain when people have to hire us to resolve these things. So I'm not going to complain about it. At the same time, I don't think that's a good use of county resources and time. Let's put it that way. All right, so organization of the board. This is the second big topic here that we're dealing with. Again, these are bullet points that you can consider for inclusion as headings under the chapter organization of the board. Not required, but these are some of the topics that we like to see addressed within board rules. Standing committees, other committees, staff assistants, scheduling and notice, public appearances at committee and county board meetings, minutes of the meetings, and then budgetary review. So let's talk about this a little bit. Let's start with committee structure. 59.13 sub 1, the board may by resolution designating the purposes and prescribing the duties thereof and manner of reporting authorize the chair to appoint committees. And so the reason I highlighted this statute is that if you look at what is required under Wisconsin statute in order to create a committee, you have to have a resolution, and that resolution has to designate the purpose and the duties and the manner of reporting for that particular committee. And so in our experience in counties, when we see a committee structure, those committees fall under generally three categories. We have statutory committees. They're required as a matter of law. The Wisconsin statutes say that you have to have these committees. Doesn't mean, by the way, that you have to have all separate committees. You can have combined committees, but the law recognizes certain committees have to exist, such as highway, zoning, human services, law enforcement, so on. Then next, we have committees that are not required by statute, but almost all counties, from what we've seen, have them. An executive or an administrative committee, a finance committee, things of that nature. And then finally, we have ad hoc, which may be considered appropriately as temporary, or other committees. Great example of that is a board rules committee that gets together once every 2 years to look at your county board rules and recommend updates and amendments to the full board. So these are the three categories of committees that we see committees typically fall into. Why are we talking about those three categories? Because it would be helpful to have your board rules identify what type of committee it is, and then establish the duties and responsibilities of those committees based upon these categories, because the responsibilities of your highway committee are going to be set out in chapter 83 of the statutes. The responsibilities of your executive committee aren't going to be will be contained nowhere in statute. So again, categorizing them appropriately helps with establishing the duties and responsibilities for those committees. Let's see here. Board rules. When it comes to standing committees, not statutory committees, standing committees, the type of committee, how the committee is comprised, how many members we have. We would prefer it be an odd number of members, because if we have an even number, there is a chance of a tie vote. We don't like tie votes. And how is the committee comprised? By whom? Remember, early on, we talked about the chair's responsibility in appointing committee members. You can always modify that and have the committee on committees appoint committee members. That's fine. Whatever it is, make sure you specify that within your board rules. What is the function of the committee? What are the duties of the committee? What kind of issues is the committee going to consider? Because that defines the jurisdictional boundaries of the committee, so that when an issue comes before the county board and is referred to a committee, we know where that issue is going to go. What is the committee's reporting relationship? In other words, do we expect a monthly report from that committee to the full board? Do we expect that committee to combine with another committee in terms of the report to the board? Do we expect that committee to have a reporting relationship with another committee? Let's define that within our board rules. Oversight authority. Remember, and all of you have heard me preach about this way too often probably, the two functions of the county board are to adopt policy and hold staff responsible for enacting that policy accountable. And so there is an oversight responsibility. what is that particular committee's oversight responsibility? Over what department are they going to maintain budgetary oversights and have to deal with any issues that arise as a result of that department's function? So let's define that oversight authority. And then how is committee leadership determined? In many counties, the county board chair says who the chair of a particular committee is going to be. That's fine. In other counties, the committee on committees determines who the chair is going to be. And that's fine too. In still other counties, we have committees themselves elect leadership for the committee. All of those opportunities, they're all fine. It's just you need to define in board rules how that process is going to transpire. All right. Ad hoc or other committees. Be aware that if our board rules provide that committees, whether they be ad hoc or temporary or other, if people are given the opportunity or authority to create a committee, that whatever committee is created, whether we call it a task force, an advisory commission, a citizen input committee, whatever we call it, it may be subject to open meetings law requirements. So we have to be very careful about what we authorize in terms of committee creation. If we intend to create a committee, let's just say so. Let's put it right within our board rules that no committee shall be created without a county board positive vote creating that committee. Let's say that right within our board rules. That way we know nobody else is going to run off and form committees, okay? If a standing committee, one that has a level of permanence, is going to continue in perpetuity until we abolish that committee, if that's intended, let's specify that, all right? Use rules, the same rules applies for these ad hoc committees about how long they're going to exist. If we intend those committees to exist until a certain date or until a certain report is submitted, let's define that within whatever resolution it is that we use to create that committee. And let's, within our board rules, state that if we create an ad hoc committee, it has to be for a defined time period. And then once that committee's work is done, the committee itself is done. Automatic, doesn't require a vote, nothing. It's automatic that committee is done. Years ago, this was a while ago, but I remember looking at a couple of county websites and taking a look at how many committees some of these counties had, and the numbers got into 30s, 40s, 50 different committees. It was ridiculous. And the reason that happened is because I think counties and county boards just created committees from time to time and never took them off the website or never officially ended that committee's tenure. Let's avoid that situation. What are the rules applicable to the committees in terms of officers, who appoints or elects the chair or vice chair of a committee? How is the committee record created and maintained? 59.23 says that the county clerk is responsible for the proceedings involving the county board and its committees. However, the statute allows the clerk to delegate authority to maintain that record to a department head, to a member of a committee, whatever the case may be. Let's work with our county clerks and figure out what is the most effective and efficient way to maintain the minutes of our meeting, create agendas, and otherwise maintain the record of committee proceedings. What is the process for removal of committee members? Does the county board chair have unilateral authority to just pull members off of a committee? In the absence of a board rule, if the county board chair appoints, the power of removal comes with the power of appointment. So the county board chair has that authority. Do we want a different process in place? Do we want the county board chair to have that unilateral authority? I don't know the answer to that. You decide the answer to that, but it's got to be in your board rules. Specify the committee chair's authority. The committee chair presumably presides at committee meetings. Does he or she set the agenda for those meetings? If the chair doesn't do that, who does that? Do items that are referred to the committee have to be taken up within a specified time frame? All right, we've all heard the concept that a particular provision can simply die in committee because the committee refuses to take it up. Do we want that? Do we want to allow that? Or do we want to say that the committee has to take up a matter that's referred by the county board within a specified time frame? Who makes reports on behalf of the committee? Is it going to be your committee chair? Is it going to be somebody else? And if your committee chair is absent from a meeting, who does it? And then you have procedural rules surrounding your committee meetings as well. Here we're going to get into comment and board participation. This is very important, but any brief comments before we get into this important topic, Jake?
I guess two. I I guess I don't know why, where this originates from, but you do see kind of a level of uncertainty. And again, maybe it's because they're not spelled out in board rules, a level of uncertainty as to what the authority of a committee chair person is. And so I think that's a really critical point you had there in the previous slide, that, to the extent there is uncertainty, make clear that a committee chair essentially has this, similar authorities as to a board chair, right? They're the ones presiding at the committee meetings. They're the ones running the meetings. I think sometimes you see this, kind of a view that, well, a committee is different from the board, and therefore, right, it has to be run, purely on consensus, and the chair really is just kind of a caretaker. And I don't think that's right. I mean, that committee chair should have some authority to run the meeting, right? To set the agenda, to preside, and actually, oversee the debate. And so, to the extent there is any uncertainty, specify that in the rules relating to committees. And then I would just maybe second make the plug, when you're having this debate, it may, I know this is a completely separate presentation that we presented on in different settings, but when you're having, a review of these committee rules, it may not be a bad time to have the discussion as to, do we really need, 36 different committees with, 54 subcommittees, not calling out any counties in particular, but, we have worked with counties, going back to my role as a county supervisor in Ozaki County, we're maybe the best example of going from, I believe it was something approaching 30 committees to 5 standing committees. So that's maybe the most extreme example. I was actually on the board when that change took place, and I can say from a younger county supervisor standpoint, it was critical that instead of having to attend 8 committee meetings in a month plus the 2 board meetings, I had my 1 committee to attend. And I'm a big advocate of, I'm not saying 5 has to be the number, but at least have that conversation. And I know, again, we've worked with several counties on this, and hopefully we'll work with others that, just have that conversation. Maybe just because you've always had a large number of committees, maybe there is a way you can create efficiencies and streamline things so that, members aren't being asked to attend 10 committee meetings a month. So just that'll be my plug.
Yeah, and I just want to follow up with a good point that Dave Henry up in Brown County made. He said, look, we have it right in our board rules in ordinance that says that every May we have to renew those ad hoc or temporary committees. And so they're going to end not every year, but every even numbered year. So after the organizational meeting, you evaluate and say, if this committee is going to continue, we need specific action continuing this committee. Joe down in Kenosha County asked another question about whether a committee has to act on a matter to extend the question, or excuse me, with the question about whether a committee has to act on it, if we address that in the board rules, do we also want to answer the question about whether the committee is required to report back to the board negative treatment of a particular measure that gets to the committee? And I think, yes, you need to address that in the board rules. In other words, does the county board itself want to hear if a committee voted down a proposal at the committee level, or does it only want to hear about stuff that's being forwarded back to the board? Let's address that within our board rules. All right, so when we speak to this concept of public comment and board participation, this comes up an awful lot too, in the context of, number one, understand that the law does not require public comment either at the board level or the committee level. That allowing the public to provide input through a public comment period is something that the county can choose to do or choose not to do. If a county chooses to do that, if a board says, look, we think we ought to have public comment either at a committee meeting or a board meeting, then define the rules associated with that public comment period. Personally, I like to see public comment at the committee level, not the board level. The reason being is that the committees are the ones that are rolling up their sleeves, doing the tough work of establishing the policy parameters associated with a particular issue. And so the public comment is more valuable at the committee level, because by the time it gets to the board, the committee should have fully vetted the particular policy question before it. That aside, you can still have public comment at county board meetings. I see it all the time, and that's just fine if you do it, but let's establish the rules for public comment. specify the time period, specify any other rules of conduct related to public comment. And then here is an important question. And I get this question quite a bit too. We have a committee meeting. We have public comment on the agenda for that committee meeting. We have a board supervisor show up at the committee meeting who is not a member of that committee, who signs up for public comment and wishes to speak. Do we have to let that board member speak during public comment? And if the answer to that is yes, do we treat that board member like any other member of the public, or do we allow that board member some latitude in the comments? Do we allow that particular supervisor to participate in debate because that person is a board member? So again, let me give you just my thoughts on this, all right? From a board member perspective, that board member is not a general member of the public. That board member has been elected by constituents to represent those constituents on the county board, and there may be a matter of business before that particular committee that is of importance to that particular supervisor, so he or she wants to make the committee aware of what those concerns are. And so I have no problem in carving out specific time for that board member to provide that type of input for the committee, separate and apart from the public comment period. I don't like inviting that particular board member to fully participate in the committee meeting. That's not what the committee meeting is for, and the board member has no right to participate in the debate because he or she is not a member of the committee. And so let's address within our board rules the role of a board member as it relates to attendance at committee meetings where that board member is not a member of the committee. In the absence of any other rule, in the absence of addressing this within your board rules, does a board member have a right to speak during public comment? It's a bit of an open question, but I would lean in favor of yes, that board member has that right. Remember, the board member has certain First Amendment rights, and so we can't limit those First Amendment rights simply because he or she is a board member. That's what would make me concerned about limiting the board member's ability to speak during public comment. We see a lot of issues that come up or arise as a result of public comment, all right? The questions that we ask on this slide are designed to get you thinking about the things that you need to address within your county board rules to make for orderly, efficient, and effective public comment. Way too broad of a topic and too deep of a dive that we'd have to do to get into the constitutional and other considerations relating to regulating public comment. That said, as a general proposition, we as counties have the ability to regulate how public comment transpires. So let's regulate that. Let's make sure we don't have profanity. Let's make sure we don't have public commenters attacking board supervisors. Let's make sure that we don't have disruptive behavior that is going to interfere with the orderly administration of our board meeting or our committee meeting. And so again, if we look at the questions and information contained on this slide, those are hopefully conversation starters for you in your county about the rules that you are going to help define the public comment period. Staff assistance to committees. What's the expectation in terms of staff involvement with the committee meetings? Is the committee going to require a report from staff at each meeting? If it requires a report, what is the format of that report? What type of information do we like to see? Let's put that within our board rules. Again, as I mentioned earlier, the county clerk is primarily responsible for keeping the record of the committee, but the county clerk can delegate that responsibility to staff if that makes more sense. So let's have a conversation about what the expectations are as it relates to keeping the record of the committee if it's done by staff. What we don't want to happen is to have 5 different committees doing it 5 different ways. That leads to chaos, inconsistency, and problems. So let's have a uniform way of dealing with keeping the record of that committee. And then the final bullet point on this is really important. Form of budget accountability. If we are talking about the dual function of the county board to be enact policy and then create accountability for the staff responsible for carrying out that policy, one of the primary areas of accountability is to budget. And so if we want to see a financial report every month as it relates to budget performance, Let's specify what that report looks like. I can tell you from a staff perspective, staff doesn't want to be surprised with questions, so they don't want to find themselves in the middle of a meeting being interrogated about budget performance if they've not prepared for that. And so I think it's only fair that we let staff know, here's the expectation for each meeting when it comes to your presentation. I want to hear how we're doing in terms of our budget. Where's our performance? What's it look like? Let's put that in our board rules. Scheduling and notice, who is responsible for making sure that we have open meetings law compliance. Closed session requirements. I never ever like people being individually responsible as board members for determining the appropriate language on the agenda for a closed session, unless you've gotten that advice from corporation counsel. Corporation counsel is going to tell you, here's what I want to see, here's what I don't want to see. You need to follow that advice because your corporation counsel is the expert on open meetings law compliance. Here's another provision that we ought to put in our board rules, that county officials, employees, or others present in closed session shall not disclose confidential information acquired in closed session. Remember, what is the statutory penalty for disclosing something discussed in closed session? There isn't one. So let's put it in our board rules that that information can't be disclosed. Along those same lines, remember that 19.89 of the statutes give board members the right to attend all committee proceedings if they want to attend, and that includes closed sessions unless we have a rule that is contrary to that. So if we want to be able to discuss certain matters outside the presence of board members who are not members of the committee, let's put a board rule in place allowing that board member to be excluded, whether it be at the call of the committee chair or by majority vote of the committee, whatever the process. Let's put it in our board rules because there are a lot of reasons that I, as counsel to a county, Jake, as attorney for a county, we may not want other people in that closed session because we're dealing with certain issues that are obviously highly confidential. So let's have a board rule in place that allows us to exclude those board members. We also have in here dealing with scheduling and notice. I want to briefly talk about resolutions that come from the committee to the board. What is the expectation about not only the content, but the form of those resolutions? What do we like to see? We ought to have a uniform form for those resolutions. We ought to identify if we're requiring a fiscal note, what are the contents of that fiscal note? Who has to sign off on that fiscal note? Same with a legal note. Has it been through corporation counsel review? And what's the expectation? Let's put that in our board rules. What is the deadline for submitting agenda items and resolutions back to the full county board? Does a committee have to get this material to the clerk or the county board chair a week in advance of the county board meeting? If that's the case, let's put it in our board rules. Budget preparation and administrative coordinator counties, that's a little bit more of a process than it is in administrator or county executive counties, because with administrative coordinator counties, we don't have the administrative coordinator presenting the budget to the full board. The administrator and the executive do have that statutory responsibility. So in administrative coordinator counties, what is our process for budget formulation? Are we going to get information from department heads and make determinations within each committee of jurisdiction, so to speak? If we do that, then let's put that within our board rules. As it relates to those counties with an executive or an administrator, I can tell you that from what I have seen, the budget process goes a lot smoother if we don't wait for the administrator to simply introduce the budget cold in October of every year. The administrator is going to want some involvement, whether it be from the finance committee or other committees. So what is that process? We're 3 minutes over time, and I rushed through the last couple of slides, Jake. Anything you wanted to add about any of the topics that I kind of rushed through a bit there toward the end?
No, I mean, I guess I was going to make the point, we see the closed session. I thought that was a really important slide that you had. Lots of questions we get relating to closed session, specifically to your point that we get the question all the time. We had closed session, somebody leaked some information. What can we do about that? Where's the statutory violation, right? And the answer is always, there's no statutory violation. Possibly there's an ethics issue, but it just gets to the point, have the discussion and have clear board rules so that you can point to something that this is the expectation when you go into closed session, and this is why confidentiality is important. Which then just leads to all the points we've been making. Have the discussion, have clear board rules so that there isn't this uncertainty, so that you're not relying on customs and practices that can change or you know, really be utilized in maybe ways that weren't anticipated.
Well, and let me end with this, is that this entire task of trying to address all of these various topics and questions within the board rules, it can be daunting. I get that. I understand that. And I can guarantee you that you're going to miss something. In 6 months from now, you're going to say, oh, I wish this was in the board rules. That's okay. Remember, at the beginning, we spoke to this concept of board rules being an evolutionary process. And so each and every time you take a look at the board rules, they're going to get better and better and better and better. All we would ask you to do is to have a level of dedication to that process. The fact that you want to look at your board rules, the fact that you want to create effective and efficient governance, that's what's important. There are resources out there to help you. We're having this discussion today. I know WCA has resources. We serve as counsel to various counties that are going through the process of updating and revising their board rules. We'd be happy to help. So understand that we understand that this is daunting, but you should tackle this. You should take a look at this, and there are resources out there to help. As a reminder, the PowerPoint slide deck is going to be posted to WCA's website. The recording of this discussion is going to be made available as soon as it on WCA's website, as soon as it's available to WCA. And we're going to continue this discussion next Wednesday, same time, same place, December 20, noon hour. So if there are others that could benefit from this discussion, please invite them in. And as always, if you have any questions, concerns, or comments, we don't have any open questions now, but if you think of something 10 minutes from now, shoot me an email, shoot Jake an email, shoot WCA an email. Jake, any parting thoughts?
Yeah, no, I mean, I guess my parting thought was going to be when we started the presentation, we had said, you know, don't use templates, but to the point that you just made, when you're going through this process, read through other county board rules, right? I mean, I mean, we would love to work with as many counties as we can on this issue. And you know, the dirty little secret is we're not starting from scratch every time. We're going to be looking at other counties to see how they've addressed issues. So you don't need to reinvent the wheel. That being said, to your point, this is not just a pure copy and paste job. So as we, you know, as we lead into next week, you know, if people want to start looking at other board rules to have more specific questions, but we have 72 different examples out there, and there's kind of the good, the bad, and the ugly. But you know, that's the whole point, is that we have a constant review and take those counties rules that you think would fit your county and adjust them and apply them to your specific needs.
So I'm going to conclude with thank you for your interest in this topic. Thank you for your service to county government. Hope everybody is enjoying the run up to the holiday season, and we will see you again next week at this time, at this place. Thank you, everybody.